Something just happened with my share screen. There we go. Okay, good morning. Um, so we're talking this morning about the transition to telehealth. And isn't it amazing how literally over the course of maybe, just a matter of weeks, we have gone from telehealth being a little bit of an outlier in our profession, all of a sudden being absolutely essential. So yeah, things have changed, and here we go. Okay. So as a licensed attorney and a licensed mental health counselor, I always let the attorney have the first slide. And so what the attorney wants to say is, these are just my personal opinions, not individual legal guidance. So let's go past that and look at what we're going to cover today. So we've got 2 hours, and we're gonna look at several things. We're gonna start with just a review of our sources of law and ethics standards. And this to me is a really important place for us to start whenever we're talking about law and ethics. One thing that you'll notice throughout this presentation is that in the bottom right-hand corner of most slides, we've got the citation. From my perspective, citing where the information comes from is probably more important than the information itself. This tells us this tells us when the information is just an opinion, and when it's a rule, and when it is maybe just a policy, right? And that also lets you go back and evaluate what I'm telling you. So you don't just have to take my word for it. You can go and look it up yourself. So the sources are really important, and we'll start by just talking about what are those sources and where is this coming from. Then we're going to spend a little bit of time developing a shared understanding of what in the world do we mean by telehealth, right? What is the definition, and what are we talking about? Then we're going to look more specifically at some of the practical requirements. So if we're using telehealth, what do we need to do? And then after that, the last 2 sections are looking at some pretty big issues that are arising under telehealth with crossing jurisdictions, and then just practically what's going on with insurance and telehealth. One of the things that I would preface before we get into the content today is that these standards are literally changing daily. I've kind of lost track of how many times we've presented this same presentation now in the last couple of weeks, but I'll tell you that every single time we've done it, we've made changes to the presentation, because some of the rules and standards and policies have changed in between the presentations. So things are very much in flux right now when it comes to healthcare and telehealth and really everything. So I'll preface it by that. Make sure that, again, that's one of the reasons that we're providing the sources. Make sure to keep going back and looking at these things, because again, I anticipate that we're going to continue to see changes in our professional environment, and specifically in telehealth. One other thing I'll just tell you for housekeeping is we've got 2 hours this morning. We have a couple spots where we're going to take quick breaks, and the breaks will do 2 things. The breaks give you an opportunity to take your earbuds out and take your headphones off, or stand up and stretch, or head to the restroom. Just gives us a chance to unplug for a minute. It also gives me a chance to review the questions that you've all posted in the Q&A function, and then respond to those. I'm looking at the participant list. We've got 98 people online right now. Just opening up the presentation to questions would probably be a little bit overwhelming of our time and our technical resources. So I would encourage you, if you have questions, put them into the Q&A function. At the breaks, I will review those, and then we'll start back up by answering your questions. Okay, so let's jump right in. So here's our sources of legal and ethical standards. So with law and ethics, it's both law and ethics, right? So the first piece is the law, and we've got federal law and we've got state law. The federal laws that really apply to our practice environment significantly are HIPAA, right? That's the federal confidentiality and privacy rule for healthcare information. And the second federal law that applies significantly to our practice environment is 42 CFR Part 2. And that is the federal, and that, oh, Shannon, your mic is open, I think. and that is 42 CFR Part 2 is the federal rule for confidentiality and privacy for substance assessment and treatment information. So those are our two federal laws that we have that impact healthcare. Everything else is regulated pretty much by state law. So states typically regulate healthcare. So the important thing to understand about the federal laws and the state laws is they both apply. And in the case of HIPAA, the federal law under HIPAA sets a minimum standard of confidentiality and privacy protection that state law must support. Now, states can have stricter rules, right? So the states can offer more protection to confidentiality, but they can't offer any less protection than is guaranteed under HIPAA. And you'll see a couple places where that all kind of comes together. But functionally what that means is that in most situations, Washington state law is stricter than HIPAA, and so that's the one that we need to follow. There are a few places where Washington state does not have rules or regulations that HIPAA does, and that means we just default to following the HIPAA standard. And I'll show you some of those. So under the state law, we really basically have three sources of laws under state law. We've got the RCW, and that's the revised code. Those are statutes enacted by the Washington State Legislature. The second thing we have are the WACs, and these are the administrative codes. These are regulations created by the executive branch of state government. Typically for us, that's the Department of Health. So RCW is the legislative branch of state government. WACs are the regulations by the executive branch of state government. And we need to follow both of those. And the third source of state law is case law. And this is where the judicial branch of state government gives us interpretation of the RCWs and the WACs, identifies standards of common law, and applies the rules. So in essence, we need to follow all three of those sources of case law. Now, what do we do when there's a conflict? What if the RCW says one thing and the WAC says a different thing? And that does happen sometimes. Well, the answer there is we always have to follow the strictest rule. And in our context, the strictest rule generally means the one that protects the client the most. So those are our legal sources of guidance. And then when we have issues that are not covered by law, now we can find guidance through our professional standards. And this is the ethics side. So a couple places that we can get those are from the ethics codes. Our professional ethics codes give us guidance that can help fill in the gaps that are not covered by legal standards. We can look to common practice. What is seen as appropriate ethical practice in our practice environment, whether that's our profession, our geographical environment, our type of practice. And then we can also look to workplace policies, right? So our professional standards can be defined by what our workplace says is appropriate conduct. But remember, if there's a conflict between the law, the ethics codes, our workplace policies, we always have to follow whatever one is the strictest. And then one last thing here under our sources of law and ethics, you'll see under the state information, I've also got regulatory opinions. So what I mean there is these are where the Department of Health finds professional misconduct. Now that doesn't create law. So the Department of Health does not create law other than the WACs, the regulations. But the regulatory opinions, the findings of misconduct, do give us a really good sense of what the Department of Health sees as the application of the standard of care. And so often we'll use those as examples of how to apply these rules. All right. So looking at the ethics codes, here I've got 6 or 7 codes of ethics. I have them listed in order of when they were most recently updated. And one thing you'll notice, this is a WMHCA, Washington Mental Health Counselors Association webinar. And what you'll notice is the American Mental Health Counselors Association ethics code has just been updated. So we updated this code, and I am on their ethics committee, and we just updated this code a couple weeks ago. So the WMHCA Code of Ethics is the newest one. For all of you, regardless of what your license type is, whether you're a social worker, a marriage and family therapist, a counselor, a psychiatrist, a psychologist, an ARNP, certified counselor, SUDP, whatever your license type is, I would recommend that if you are doing counseling, psychotherapy work, that you become familiar with all of these ethics codes. And the reason that I say that is taken together, all of these allied codes give us a really well-rounded picture of what the standard of care is, right? And different codes go into detail on different aspects of practice. And when you look at them all together, you get the best picture of what our standard of care is. You know, one of the things that I do when I'm looking into an ethical dilemma that I haven't analyzed before, and sometimes even when it is one that I've analyzed before, what I frequently will do is open 6 or 7 tabs on my internet browser, Google each one of these ethics codes, search for the pertinent section, and really look at what all the ethics codes taken together say about a certain topic. And you're going to see that we're going to do that this morning. On a few of the topics that we are going to talk about, we're going to look at all the ethics codes together and what the emerging standard of care is. And here's a good example of that. So if we look at all these ethics codes, the general standard for using any kind of technology in the clinical environment is this. For any technology that we use in practice, we need to have a current and adequate understanding, knowledge, skills, training, to be able to use that technology competently, safely, and effectively. So the bottom line here is, if you're going to use something, if you're going to use some technology in the clinical space, it's our obligation as clinicians to know how to use it effectively, safely, and competently. And my guess is that's a big part of why you're all here this morning. Okay. So let's talk a little bit about what is telehealth. What are we even talking about when we talk about telehealth? So there have been a lot of sort of names for this that have been floating around. That we've called it distance counseling, telemedicine, cyber counseling, online therapy, internet therapy, all kinds of different names. It all means the same thing. There's no legal or technical difference between all of these names. But I think in the last couple weeks, as a profession, we have sort of solidified telehealth as the word that we're all sort of using now. So here's the definition of telehealth that we can share. It is any therapeutic, any clinical intervention that is provided by you, a mental health or behavioral health provider, to a client who is geographically separated from you and facilitated using technology. So that's telehealth, when there's a geographic space between you and your client, and you're providing clinical services to that client through the use of technology. Now, we do have in this second quote, telemedicine. Telemedicine is defined under Washington state law, and it explicitly does not include telephone communications, email, or fax communications. Now, the reason that I bring this up is this Washington statute, applies to standards for health insurance reimbursement. And based on Medicare rules, telemedicine does not include telephone. They're just under Medicare and under for reimbursement. That's a different thing. It's reimbursed differently. Why I want to point this out, though, is that when we're talking about telehealth, use of telephone services still would be treated the same as telehealth for all other purposes. As far as the standards that we're talking about, the practice requirements, the standard of care, we can include telephone communications in that. The one difference is for insurance reimbursement and under Medicare reimbursement, telephone communications are treated differently. So I just wanted to point that one out. All right. So here's a little bit of historical context. I really like sharing this just to sort of help understand where we're at right now. So this is a quote that I pulled out of a journal article. And the quote is this: a patient should come to the therapist's office for treatment. The blank or other technological devices, for example, blank and blank, should not be allowed to create barriers between the therapist and the patient. Right? This is a statement about making sure that technology enhances the clinical relationship, not getting in the way of it. And so, what do you think these technological devices are? What do you think this is that's being referred to? The internet, telehealth, maybe even email? Well, here's what's really interesting. This is an article from 1992. And what they were talking about here was the telephone, answering machines, and beepers. And what I really kind of love about this quote was in 1992, the, the potential negative impact on the clinical relationship of telephones, answering machines, and beepers was actually a serious issue, an issue that was being discussed in the scholarly literature. My guess is none of you have thought about the potential impact of your beeper or answering machine has on your clients in decades. And what this kind of demonstrates, I think, is that often our profession tends to lag a little bit behind the technology, right? And technology advances, and we're not quite sure how to apply it most effectively to the clinical world. And so there's a lot of concerns, right? And we have to figure out, how do we balance providing the best care to our clients with technological advances. And then eventually things kind of shake out and normalize, and we stop worrying about it, and it just becomes a part of our practice. And I think we're at one of those transition times right now, right? Where we are all, and this is not just us, but throughout the entire world, our profession now is rapidly transitioning to an online environment and trying to figure out how best to do that. And there'll be a time when this will kind of shake out, and it will be second nature to all of us, and we won't be as concerned about trying to figure out the issues, because we'll have it largely figured out. Okay, so the place to start is that we really don't have any specific laws or regulations specifically about telehealth for the mental health professions in Washington. Some states do, we really don't. But what this means is that we still need to meet all the same requirements of in-person clinical work when we are providing telehealth, right? Where we can find some of the standards of care specifically applying to telehealth, however, we can find that from the ethics codes. Since Washington law says, look, follow all the same rules, applies exactly the same in person or via telehealth. We do have one policy statement. This was way back in 2016. The Washington Examining Board of Psychology published a policy that basically mirrored this. The examining board said, for psychologists engaging in telehealth, all the same standards and rules of in-person services apply, specifically when it comes to the clinical standards, confidentiality standards, and all the ethics. So consider everything that you know about what you're required to do as part of your clinical practice. It applies in the real world and applies the same way in the virtual world when we're doing telehealth. Okay, so then the question becomes, how do we meet these in-person standards when we're providing services via telehealth? Well, there's really five main considerations. So the first one is telehealth clinically appropriate for your individual client? That's the first consideration. Second one is, do you have effective training to meet that standard that we talked about of being able to provide telehealth services in an effective and safe manner, right? Next one is, are you using the appropriate technology? What is the standard of care for the technology that we're using? Fourth one is making sure that we're providing informed consent for the telehealth. And then the last one is making sure that you have the proper licensure. You all do have the proper licensure to provide telehealth. There's no specific additional license that's required, but there's a big issue with crossing jurisdictions. So we'll talk about that at the end of the morning this morning. So starting with clinically appropriate, this comes from the ethics codes. And the ethics codes say we really do need to specifically consider a wide range of client needs and attributes when we're making that assessment that telehealth is appropriate for that individual client. And you see what some of those considerations are. You know, we are in a slightly different situation right now where in-person clinical work is maybe still possible, but it's not widely available for most clients. So for many clients, the only option right now is telehealth. And so we really are broadening that appropriateness. And in maybe even a month ago, there were certain clients or certain situations where we would have said telehealth just isn't appropriate. We're rapidly moving towards a situation where telehealth is the only option, right? So it really is a case-by-case, client-by-client analysis. And we do have to continue to assess the differences between face-to-face and telehealth communication. And there's really pluses and minuses of both, right? I'm sure you all have been doing telehealth and starting to see this. You know, there's information that we just don't have when you're communicating via technology. I mean, one of the obvious ones is smells, right? That's a piece of information that might be relevant to the clinical environment, that when you're online you just can't smell. At the same time, I think there are some benefits as well to that, the differences in the communication when it's online. For example, what I find with telehealth is often there's a lot more direct eye contact and direct communication between the client and the clinician when it's online. So there's just differences, and we do need to recognize what some of those differences are. Now, as of March 23rd, Washington State issued an exemption to the stay-at-home order for essential businesses. So among those businesses exempted from the stay-at-home order, who are allowed to continue to interact with the public, are behavioral health workers responsible for providing treatment or for coordinating treatment or providing outreach to individuals in need of mental health or substance use disorder services. That is absolutely us, right? So as behavioral health providers, we are exempted from the stay-at-home order when our services are needed. So we may still practice. Just yesterday, the federal CDC released some guidelines for essential workers who are continuing to interact with the public throughout this crisis. And these guidelines are similar to what we would have recommended, a day or two ago, but it's really helpful to actually see these guidelines. So if you find that you do need to still keep working with clients in person, there's a couple things you'll want to do. The first one is I would recommend documenting why the in-person session is necessary or is in the best interest of the client. And there's all kinds of reasons that might be. There might be access to technology reasons. There might be clinical reasons that on a case-by-case basis, continuing to see a client in person might be necessary. So you want to document that. And if you are going to see clients in person, at a minimum, you should follow these steps. First one is make sure that at least at a minimum at the beginning of the workday, you are assessing your own symptoms and taking your temperature to make sure that you can document that that you did not have reason to believe that you might be infected. Second one is, even without a temperature or symptoms, you continue to self-monitor your own wellness and cease seeing clients if there's any reason to think that you may be actively sick. We're going to skip that third one for a minute and come back to it at the end. Social distancing, you should do whatever you can to maintain that 6 feet of space between you and other people. One thing this might even look like is having your sessions in a space other than your office. If you have a group room or even in a waiting room where you can get more space. So maybe in time, spacing out your clients so that you don't have interaction between clients coming into the office, and maybe finding just more physical space where you and your client can be a little bit more spaced out during the session. Then disinfecting and cleaning any common or shared spaces, your waiting room, the chair your client sits in, anything where people are likely to be touching the same surfaces. In between clients really makes sense to be disinfecting. And then the last one is wearing a mask. Shannon and I talked about this earlier this morning. I'm not really sure how feasible it is to conduct counseling or therapy wearing a face mask. I would consider it. if you do need to see clients in person. And again, remember that the point of wearing a face mask is not necessarily to protect yourself, but it is to keep you from potentially spreading the virus if you don't know that you are infected. So I would consider wearing a face mask. You might also, if it's just not feasible, document why it was more in the client's interest for you not to wear a face mask than to wear one. Okay, so that's our assessment of, is telehealth appropriate, clinically appropriate for each individual client? So our next piece is training. So remember, the standard is, if you're offering telehealth, this comes from the ethics codes. If you're offering telehealth, you need to have sufficient knowledge and skills regarding the technology and legal, ethical, and clinical considerations. That skill, knowledge and skill, can be developed through a training program, through your own experience, through supervision and consultation. There is not one specific course that is required in order to have these skills. Now, we do have a Washington state law on training for telemedicine. So right now, the law says that as of January 1st, healthcare professionals providing telemedicine may, and that's the important part, may complete a state-designated telemedicine training. And this is through the Telemedicine Collaborative, who will make this training available. Interestingly, there's an update to this law that is scheduled to take effect in a year, next January of 2021. And the change will be, instead of being a may, that providers who provide telehealth may take this training, it will become a must. So as of January 1st of 2021, there is a Washington state mandated training for telehealth. Now, in the statute, the statute also says an equivalent, a training with equivalent content will be allowed. And the content is very general. It requires training on clinical and legal and ethical implications of telemedicine. Now, we might see some more specific policy guidelines coming into effect before then. But just keep in mind that this is coming next year, to have the requirement for training. And my guess is what we're doing right now probably would end up being of equivalent content and meeting that requirement. Well, and here we go. Here's the requirements. State and federal laws, liability, informed consent, and then whatever else might by policy be required. Before we have that, and that training is not in place yet, but before we have that, here are just a couple of sources of some good quality training. There's lots of other ones as well. I like both of these sources because I have interacted with both Person-Centered Tech and the Telehealth Certification Institute on many occasions in the past. And my personal understanding is that for both of these organizations, their primary goal is to ensure that high quality, competent, effective telehealth is happening. And so I think the content of their training is focused very much on making sure that you are well equipped to be as clinically appropriate or clinically effective as possible. So these are a place to start if you're looking for training. There's lots of other good ones as well. Okay, so we've talked then about is telehealth clinically appropriate for an individual client? We've also talked about, do you have appropriate training, skills, and knowledge? The next thing is your video conferencing platform appropriate? So we'll start again with the ethics codes and take it all together. The ethics codes say, look, anytime you're choosing some technology, you should be considering optimizing quality and security, adhering to standards of best practice. What is the best practice that's accepted within our profession? Are you using current technology that best serves the client? You don't have to use the newest thing, but is there something that is a better option rather than what you've been using? Are you protecting client confidentiality? And are you taking into account the cultural, environmental, economic, physical, mental, linguistic issues of your individual client. So all of these things are considerations that we want to be thinking about when deciding what technology to use. So the question is, so what about things that are widely available, like Skype, FaceTime? What about Zoom? Well, it's all about HIPAA compliance. And HIPAA compliance, the way you know whether or not your technology is HIPAA compliant is, or at least a minimum standard of how you know, is that if they will issue you a business associate agreement. And here's what that means. Under HIPAA, we are required to protect our client information to a certain standard, right? Anytime, as part of your practice, you are releasing protected health information to a third party that is not covered by HIPAA, meaning not a healthcare provider and not an insurance company, you must have a contract signed by that third party agreeing to comply with the terms of HIPAA. So that's the standard to determine if your video conferencing platform is appropriate. Now, that's changed a little bit. As of March 17th, the US Department of Health and Human Services, and that's the federal organization that enforces HIPAA, has said we are not changing this rule regarding the need for using HIPAA compliant video conferencing technology for telehealth. But we are saying is we recognize that that might be a barrier to continuity of care. And so this is the federal government saying we are agreeing not to enforce this aspect of HIPAA while we are under this public health emergency. Okay, so the key here is the HIPAA regulators have said the rule requiring HIPAA compliance for your video conferencing technology still is in effect. It still applies. However, if you need to use a different technology while we're in the midst of this crisis, we will not enforce this rule against you. That's basically what's being said. Explicitly, the US Department of Health and Human Services said things like FaceTime, Facebook Messenger video chat, Google Hangouts, Skype, these are acceptable for the time being, even though they are not HIPAA compliant. You may use these. If you do use a non-HIPAA compliant platform, then you do need to be making use of any available encryption or privacy options that are available in those non-HIPAA compliant versions. What is still unacceptable, specifically under this new Department of Health and Human Services policy, is you may not use any communication platform that is public facing, right? So anything that is generally that is acceptable to the general public or accessible to the general public cannot be used for confidential communications. So, obviously you can't conduct therapy via Twitter, right? That kind of thing. And just here are some links to those policies so that you can go back and actually read the text of them yourself. Okay, so when we're talking about what platforms to use for video conferencing, is the business associates agreement all we need to think about when we're thinking about what's appropriate? Well, there's a couple other things. So one is security, and I'm sure you have all been hearing, just like I have, about Zoom's security issues, and that because all of a sudden so many people are using Zoom, a lot of these issues now have gotten a lot more coverage. You should be considering what is the most, how do I maximize security and accessibility? So you should be balancing that. Also, we need to think about our skill with the technology, and also then assessing client skill. So we're always, when you're looking at security of technology, there's always a balancing, right? There's ease of access versus how secure it is. And typically when technology is easier for a client to access, the security is lower. If the security is higher, it's a little bit more difficult to access, right? With things like logins and passwords and that kind of thing. So we're always looking to balance that. One of the other things that I strongly recommend is not to rely on one single platform. Things can happen, and what we've all been seeing in the last few weeks is that some of these telehealth platforms just get overwhelmed and connectivity issues arise, or even just individual client issues with getting on a certain platform. So with that platform redundancy, I often recommend that you have at least two options. What you might want to do is have, say, a HIPAA compliant platform. And for example, what I'm using is DoxyMe, DOXY.me. So DoxyMe is my primary, but I have Zoom as a backup just in case. And then as a backup to that is phone communications, right? So I'm not relying on just having one option. And then the last thing to think about is not just the security of the video conferencing platform, but also the security of your network, how are you getting onto the internet. So for example, using a public Wi-Fi is probably not secure enough, right? Because even if your telehealth platform is secure, your computer communicating with the internet might not be so secure. Okay, so here's our break. What we're gonna do is take 5 minutes, get up and stretch and disconnect for a minute, and I will read through the questions and we will start right back up in 5 minutes with addressing your specific questions. Of doing these workshops is the questions, because I have no idea what to expect, and it's often great things that I didn't think to bring up. I'm gonna start with a couple of the easy questions. There were great questions to ask. So one was specifically about these platforms we're talking about. So some of the HIPAA compliant platforms out there are, the one that I'm using is called DoxyMe, DoxY.me, DoxyMe. Another HIPAA compliant video conferencing platform is VC, capital V as in Victor, and then SEE. That's one. Simple Practice, I know through their electronic records system, Simple Practice has an integrated telehealth system that I've heard some good feedback about. There's also a HIPAA compliant version of Zoom. It's pretty expensive, but it's really more intended for groups. So that is often a good option for groups. But there's a whole bunch of other ones out there. And the first way to tell whether your video conferencing platform is minimally sufficient is to see if they offer a HIPAA business associates agreement. So if they will give you a business associates agreement, then it is compliant. There's also a version of Microsoft Teams that issues a business associate agreement. So that's out there too. Now, with regard to, there was a question about, should we be documenting in our notes which platform we're using? There's actually no rule either way saying that we should or that we can't. In general, I don't really see a benefit in specifying in your notes which platform it was, particularly given that as long as you are HIPAA compliant, and right now, Zoom, Skype, FaceTime are HIPAA compliant in that the enforcement relaxation rules allowing it. As long as they're HIPAA compliant, there's really no need to document exactly which one it was. So generally, I wouldn't necessarily do that. There was a really great question about the potential for client abandonment. So the issue being, if my client wants to keep coming in person, and I am deemed an essential business, but I don't want to run the risk of being infected, and I don't want to come in person, is that abandonment? There's an easy answer here and a more complicated answer. The easy answer is no, it's not abandonment. A more complicated answer is why. So there's a difference between legal abandonment and a client feeling abandoned. A client feeling abandoned is a clinical issue. Legal abandonment is a legal issue, right? And here's the difference. Legal abandonment is where you as a healthcare provider unilaterally withdraw treatment from a client without providing the client an opportunity to continue at an equal or higher level. So that's legal abandonment. Based on the situation we're in, if you said to a client, hey, I'm sorry, due to the current public health emergency, I'm not seeing clients, and so I'm canceling our session, and that's it. That's abandonment. On the other hand, if you said to a client, given the current public health situation, I cannot continue to see clients in person. Here's the options. I'll continue to work with you via telehealth. Um, I could help you try and find a clinician that might see you in person, but that might be pretty difficult. I can refer you to your insurance provider for referrals, and I can send you to Psychology Today to find referrals. That would probably be sufficient to avoid a claim of abandonment. So remember, it's not that once you start work with a client, you have to do whatever they want until they change their mind. Abandonment means, or I mean, to protect against abandonment means you need to give them the opportunity to continue care at an equal or higher level. They can choose not to, but you have to give them that opportunity. There were a whole bunch of questions about informed consent form and documentation and practice across jurisdictions, and that's what we're going to be covering next. So we will talk about those. And there was a question about does appropriate training equal certification? And that's a great question. I'm really glad that was asked. The answer there is absolutely no. Training and certification are not equivalent. And here's why I say that. There's no requirement for you to have any kind of specific certification in telehealth or distance counseling. There's nothing wrong with it, but that doesn't change your ability to provide distance counseling or telehealth. And a certification doesn't necessarily mean that you've had appropriate training, right? These are two different things. There are some certification processes out there that are very much tied to really good quality information that's in essence saying, if we certify you in telehealth, we will stand behind the fact that you have been absolutely properly trained. There are other places that will in essence say, we'll certify you for telehealth as long as you pay us. That's it. It doesn't really make any difference what skills you've acquired or not acquired. So you have to be really mindful about that certification is not necessarily equivalent to adequate training or knowledge, and certification is not in any way required. There was another question about group sessions in telehealth. And so when we're talking about assessing the appropriateness of telehealth for individual clients, we can also look at that as group. So all these standards apply the same if you're doing group work, just as if you're doing individual work. And you absolutely can conduct group therapy or group counseling via telehealth. One of the things to think about, though, is to make sure that the platform you're using has the functionality to support group meetings. And I know, for example, on DoxyMe, the free version, they do have a free version. Their free version does not support groups. If you want to have multiple clients attend, you have to have the paid version. Speaking of that, I saw some pretty interesting guidance from Roy down at Person Centered Tech down in Portland a little while ago, and his recommendation that I really thought was interesting. So he said, if you're using the free version of a video conferencing platform, really consider if you can start paying for it. And part of the reason for that is these video conferencing platform providers really need to have users paying for subscriptions so that they can fund the upgrades and the increases that are necessary right now. So his point was, if you can afford to pay for it, really consider doing that, because they probably need that income to be providing us the service that we need them to be providing us with. So that was an interesting piece of guidance. Okay, so there's a bunch of other questions that we haven't yet addressed, but much of that will be in the next section, and I do have them here, so I'll make sure that we do cover that information. Okay, so we're talking about BAAs and teleconferencing. How about with your phone? Well, here's the easy answer. Traditional phone services, right? And that includes cell phones. So traditional phone services from phone companies, Verizon, AT&T, those are explicitly allowed under HIPAA, and no business associates agreement is needed. So you can communicate with clients via the phone, and under HIPAA rules, it functions just the same as communicating with a client in person. Now, the difference here, though, is in voice over internet protocol. So voice over internet protocol, for example, Google Voice, is not a phone service. It is actually data being sent through the internet. With voice over internet protocol, if you're using that type of communication, you do need to have a HIPAA business associates agreement. Even though you're actually using your phone, it's really functioning more like an app, and it's not going through the phone service. And then you do need a business associates agreement. Okay, so this came from another time that we were presenting this information and got a bunch of questions about actually phone use. And are you required to have two physically separated phones? And the answer here is no. But there are some things to consider. One is, if you're using one physical phone for both your clinical interaction with clients and your personal interaction, when you answer the phone, you need to have an understanding of who's on the other side to to inform how you answer that phone. So you want to be interacting in a professional manner, even when it's clients or potential clients. The other thing to think about is the security of your personal phone. So when you're installing apps on your phone, it's difficult to know how secure those are unless you've read all the terms and conditions of use, which probably most of us don't do. So rather than to know exactly what kind of information each app is accessing, it might be easier to have a separate phone that you use for interaction with clients that has no apps installed at all, and then you don't have to worry about what's being accessed. Same thing with physical security. If you're using your personal phone to communicate with clients, then you need to have a higher level of just physical security of that phone. You can't necessarily then, let your spouse or friend use your phone because it's got PHI on it. If you're using two separate phones, now it's easier to then control the access to your phone with PHI, protected health information, and have less concern about your personal phone. Okay, so that's the technology. Now it brings us to disclosure and consent. Okay, so Washington does not have any specific requirement for a special consent or disclosure form for telehealth. You still are required to provide the same disclosure that you would for in-person. Now, that being said, just like any other clinical intervention or modality or tool that we use in the clinical environment, we still need to be providing clients with sufficient information for informed consent. So here are some of the things, and this all comes from the ethics code. Washington doesn't have any requirements of anything specific that you need to tell clients when you're doing telehealth. The ethics codes, though, give us some guidance on what types of things we do need to talk about, right? So one is when telehealth is appropriate and effective, right? So if there's any rule outs that where you do not feel that you are competent or effective to provide clinical services for telehealth, that's something that probably should be discussed. You also want to have some kind of an emergency process. So what happens if your client who is remote from you needs emergency services? How do you get those services? One way to do this in a telehealth disclosure and consent is to make sure that your client is telling you their physical location during the sessions, and that your client has identified an emergency point of contact person that you can contact on their behalf. You also want to have some kind of procedure in case of technological failure, right? And what that might be is what we talked about earlier, a backup platform, and then maybe email or phone communications as a backup to that. I want to talk about the risks and benefits of telehealth. Generally, I mean, the big benefit right now is accessibility, right? You can continue to provide services via telehealth where maybe in-person services are not even available. Some of the risks are the risks of confidentiality and security, because you don't have control over the client's environment, right? That who is overhearing what they're saying, who has access to their computer, all that kind of thing. And part of what you want to do is letting the client know that it's their responsibility to make sure that they are maintaining security of their computer and their internet connection, that they are identifying an appropriate place to hold the the session because you're not able to control that as you would in your own office. So you want to be providing clients with information about where your practice is located. You're doing that anyway, though. Your informed consent form, your required informed consent form, already has your practice address and phone number. You also want to address now there probably aren't going to be time zone differences because we're probably not crossing state borders, but we'll talk about that. That might be happening. And just looking at what other issues may impact services, if there's cultural, language issues, and then insurance. We're going to talk in more detail about insurance. In general, in your informed consent form, you really probably want to be saying something to the effect of, I can't tell you whether your insurance covers telehealth. That's up to you to determine, right? Because you probably don't have a way to know for sure. Okay, now there were a bunch of questions about, do you have a template for this? And the problem, and the easy answer is no. I actually don't have a template, and the reason for that is this is not a legally mandated document. This is a document that reflects your practice, and so any sort of boilerplate sample likely does not accurately affect how you or reflect the nuance of your practice. Now, one thing that I've seen in a lot of telehealth disclosure and consent forms that I think is really problematic are a few things. One, I think it's not a good idea in your disclosure and consent form to identify the specific platform you're using, because now you may be locking yourself into using one specific technology when you need the flexibility to do others. And there's no requirement that be in a written document. The other thing is be conceptually be aware that what this is all about is you providing information to your clients, right? This is you helping your clients have enough information to consent. What I see too often is that clinicians try and make this into a waiver of liability and say something like, therefore, client, you accept all the risks and agree to hold me harmless. Number one, that's just not effective. It wouldn't work anyway. I mean, it just wouldn't be legally effective. Number two, it really flips around the whole point of this document, that this isn't about you saying it's not my fault. This is about you saying, client, I want you to have a good understanding of what we're doing so you can say yes or no, right? So I strongly recommend that you do not use a document that attempts to waive liability or shift liability. Okay. So let's talk a little bit more specifically about documentation. So one of the other challenges that comes up a lot is, how do you get clients to sign documents, right, when they're remote? A month ago, we generally would say you really need to see clients in person at least one time and have them sign your documents. That's just maybe not feasible right now. So one of the challenges here is your general practice disclosure and consent form. So not a telehealth disclosure, but just your general clinical disclosure and consent form. A legal requirement of that form is that it is signed and dated by both the clinician and the client. So that can be kind of a challenge. There are a couple ways to do this, right? So one option would be to make your disclosure forms available either online or email them to a new client. Have the client print out the forms, sign them, scan them, and then send them back to you. Then you print that document out and you countersign it. So there's no requirement that the client and you sign and date at the same time. It's just that informed consent and disclosure form needs to be signed and dated by both the client and you. So it can be done at different times. So that's one option. I'm aware, however, that for a lot of clients, the technological aspects of that may not be plausible. Like they just may not have the ability or the technology to be able to do that. So another option is to kind of go from high tech to low tech. Another option might be to actually mail a hard copy of your documents to your clients with a self-addressed stamped envelope for them to return it, sign it, and put it back in the mail, right? Another option might be to use something like a DocuSign uh, application. Now, if you're using a third-party process to send documents to your clients, have them sign online, and then send it back to you, you need to make sure that you've gotten a business associates agreement with that company, right? Because you are releasing protected client health information to that third party that's facilitating the online signing of the documents. But I think in the long run, that is probably our best solution. That's really what we're going to need to be doing is having um, some way for clients to access and sign documents online. There was a question about what about just a verbal consent for treatment and a verbal authorization for an ROI? The law for both of those, the law says the disclosure and consent form for treatment must be signed and dated. The Washington law also says for an authorization of disclosure, an ROI, to be valid, it must be in writing and signed and dated. So those are legal requirements of the document. Now, right now, of course, things are different, right? So if it's truly impossible to get a signature, what I would recommend is that you document in the client record exactly the document that was provided to the client, right? So with the consent form, make sure that you do get the consent form somehow to your client, put a blank copy of the consent form in the client record and document this form was provided to the client. We discussed any questions the client had. The client consented to it. Client was unable to provide a signed copy because of X, Y, and Z, right? Now, at least you've documented why there's no signed informed consent form. And you've also documented that you really met the requirements of providing them that information and getting their consent. When it comes to an ROI, it's a little bit more tricky because there's a legal requirement that be in writing. If it's absolutely necessary to release information without having a written ROI, I would do the same thing of documenting explicitly what was authorized by the client, who the release was authorized to be made to, what information is to be released, when that authorization expires, and why it was not possible to get that in writing. So I know that's a little bit challenging right now, and we're just trying to figure out how best to document the thing that we maybe just cannot do. Let's see. Oh, right. And then there's one other question that was really kind of not related to any of this, but I think is really worth talking about. The question that came up about malpractice insurance. And whether or not if someone is covered in their workplace by a policy, should they have their own malpractice insurance? And I'm going to tie this back to telehealth. My answer is generally yes. You are almost always better to be overinsured than to be underinsured. And if somebody else is providing you with your malpractice insurance, it is possible that in a worst case scenario, your interests and their interests could diverge, and you would need to have your own your own malpractice insurance. On that same topic, most malpractice insurance providers do cover you already for telehealth. So I do know that I've communicated with CPH and HPSO, two of the primary malpractice insurance providers for counselors. And both of those companies are saying that telehealth is included already in your coverage as long as that is consistent with your licensure, which in Washington it is. There's no special licensure that you need to conduct telehealth. If you have malpractice insurance from someone other than CPH or HSPO, and maybe even if you have those insurance policies, it might be a good idea to just check in and make sure that you do have coverage. My guess, though, is that everybody does. That in general, malpractice insurance policies have been covering telehealth for quite a while now. All right. So now let's talk a bit about technology crossing jurisdictions. Okay, so here's a place to start. Several years ago, I came across a couple websites that made me really start looking into this. The first one was this one that advertised low-cost therapy And one of the benefits of this online low-cost therapy was that it was completely confidential, even to the point that your clinician would never know who you were. And again, this to me kind of raised a red flag, thinking, I don't really have any idea how a clinician can provide competent and ethical counseling when they have no idea who their client is. So this struck me as problematic. I also saw this. I know this is hard to read, but I'll tell you what it says. This was an online counseling website where clients could just connect to a clinician and through this company get online counseling. There was nothing in this. When I first saw this website, there was nothing here that identified states, like what state was the client from, what was the counselor from. It just connected clients and counselors. I thought that seems kind of disturbing to me. So I read the fine print, the terms and conditions, and on this website, what they said was, our understanding is that the counseling is occurring in the therapist's location, and it's the therapist's responsibility to make sure that they're providing services that are allowed, right? To me, this was an even bigger red flag, that is not the state of the law. The state of the law is when telehealth is occurring, it occurs in two locations: the physical location of the clinician and the physical location of the client. And when telehealth occurs in those two locations, the clinician must comply with the regulations and the rules in both their physical location and the client's physical location. This is a state-by-state analysis that it depends on the local rules on for where your client is located, and the states regulate this all over the place. Some states explicitly say that services are prohibited unless the provider is licensed by them. Some states have temporary practice or emergency practice rules. Some states have relocation rules that allow you to continue working with a client for a limited amount of time. And some states just require that you register with them or let them know that you have a client in their state. But the bottom line is, if your client is physically present in a state other than Washington during the session, you are obligated to comply with the rules in that state. Now, there are a few states that have very specific rules on this. Massachusetts, New York, and Ohio are some of these. Now, everything is different right now, right? For example, I just yesterday saw that Massachusetts has a policy temporarily waiving their prohibition against out-of-state telehealth providers providing services within Massachusetts. So that literally just happened yesterday. Right now, what my recommendation generally is prioritize continuity of care and client best interest. So for example, if you have an in-person client who was, say, a university student here in Washington and relocated back to their home state during this current public health crisis, I would recommend that you continue to provide services to that client to facilitate continuity of care, but you do a couple things. One, you attempt to find out what the rule is in that client's location and attempt to comply with it. Also, make it a priority to clearly articulate to the client that eventually you will need to transition them to local care. And that might mean that they come back to Washington and you are their local care. Or it might mean that they are staying outside of Washington and eventually you will need to transition them back to somebody locally, whether it's telehealth or in person. Let's see. Yeah, so we do have some Washington state policy on this. We don't have any regulations or rules, but the Washington state policy is, again, if you're providing services to a client outside of the state of Washington, you are obligated to be in compliance with the rules and the laws of the location where your client is. Now, before we move on to insurance, a couple other issues that came up with in the questions. One is, okay, so we're talking about clients being outside of Washington. What about when you as the clinician are outside of Washington? Okay, so the same analysis still applies. Let's say hypothetically that you are a Washington licensed clinician, your client is in Washington, and you are temporarily or relocated to Oregon, say, during this time. Can you provide services from Oregon? Okay, so the first thing is you've got to comply with the rules where your client is and the rules where you are. And if it's different, you still have to comply with the Washington state rules, even if neither you or your client are in Washington, because you're licensed by Washington. Okay, so the first piece is Washington does not have any restriction or prohibition against you providing services from outside of Washington. So if you are outside of Washington during your telehealth service, that is not in any way a violation of the Washington rules. But what you do need to think about is now you have to comply with the rules of the state you are located in. What's really interesting to me, and this is sort of anecdotal, is that lately many states seem to not be particularly troubled by a clinician providing telehealth from their state, right? As an example of that, I recently was consulting with a psychologist who had relocated from Washington to California. The psychologist was licensed in Washington and was in the process of applying for licensure in California. This psychologist had clients still in Washington and was planning to provide telehealth services from California under a Washington license to clients in Washington. And this psychologist asked the California Board for Behavioral Sciences if that was restricted. And really interestingly, the response back from the board to this individual psychologist was, as long as you are licensed in the jurisdiction your clients are located in, we do not restrict you from providing services from California, which really surprised me. But that is sort of consistent from what I've been hearing. So if this is the bottom line. If it's temporary, that you are outside of the state of Washington and you're temporarily providing services back to your clients in Washington, I wouldn't worry about it. If it's going to become a permanent or long-term thing, now you need to start thinking about that state is likely going to want to do two things. They're going to want to regulate the healthcare that you're providing from their state, and they are also going to want to have you file a tax return. They're going to want to be collecting the income tax for the income you're earning in their state. So if it's anything more than temporary, I would recommend that you look into what that state requires. The other question was, what about practicing where a client is outside of the United States? And counterintuitively, I am much less concerned about crossing international boundaries than crossing state borders. And part of this, and there's a couple reasons for this. One reason is many if not most, countries don't regulate counseling. They regulate the practice of psychology, but they don't generally regulate counseling. So if your client is in a country where counseling isn't regulated, Washington is the only regulator, and you're in compliance with your Washington rules. The other reason for that is a lot of the risk here is that the other jurisdiction files a complaint with Washington that you're practicing without a license, or that you're sued in that other jurisdiction and you don't have and part of that lawsuit is that you're practicing without a license in that jurisdiction. Both of those things could happen with practice in another state, and both of those are much less likely to happen if you're practicing with a client in another country. But again, just in the current right now, I would say prioritize continuity of care and client best interest over maybe the technical restrictions on practicing across state or international boundaries. Okay, so now that brings us to insurance. So we'll start with 10 years ago, the Washington Mental Health Parity Act of 2010 was a law that required that insurance companies provide equivalent coverage for mental health services to the same extent that they provide that coverage to medical services. And so what this said was, if an insurance policy, for example, covered telemedicine, then it was required to also cover telehealth for mental health services. Now, what I often hear that's slightly incorrect is the Mental Health Parity Act did not require insurance companies to cover telehealth. It just said if you do cover telehealth for medical, on the medical side, you must also then cover it in the same way for mental health. So the parity was not between in-person and telehealth. The parity was to line up the medical coverage with the mental health coverage. Now, most of what's going on with insurance is all about the contractual relationship between you as an in-network provider and the insurance company. So most of the reimbursement requirements and standards are not law, they're just a contractual agreement. So based on that, this stuff is changing very rapidly because of our current situation. So one of the best pieces of advice that I can give you when it comes to billing is be in contact with the insurance companies that you are in network with. This stuff is rapidly changing, and different insurance companies have slightly different policies right now. So be checking in with your in-network insurance companies for updates. Now, for example, Primera has provided some guidance on the modifiers to use. Now, different insurance companies are doing this slightly differently, but this generally is consistent. So for telehealth, when you're in network and you're billing insurance, you will use the same procedure code, the same CPT code, but you need to use a modifier that specifies that this was telehealth. The GQ, the middle one there, the GQ modifier is for non-real-time communications. So it's non-interactive. It's where a client will send information to you, you assess that information and send something back. So that's not what we're doing. What we're doing is going to be either 95 or GT. And basically the information that I've gotten is that insurance companies are sort of split on which one they want you to use, the 95 modifier or the GT modifier. My recommendation is just contact the insurance companies you're in network with and ask them, or go to their website, and they tend to be publishing guidance because they're getting so many questions on these. Similarly, Primera has provided, and there's the link to the Primera guidance, but Primera has also given some guidance on what to use as the place of service code. So instead of the code being 11, which is in office, it would be 02, which means that the service was telehealth. Just in the last week or so, the state of Washington has released some guidance to insurance providers. So this is the Washington governor providing rules to insurance providers who are operating within Washington on what they must do. And this has changed things a lot. So the first change on March 25th was that for in-network now, in-network telehealth services cannot be reimbursed at a lower rate than traditional in-person services. So as of March 25th, insurance companies must now start reimbursing telehealth at the same rate as in-person. Second, and this is huge too, second, for insurance plans that covered medically necessary services, but excluded telemedicine, now Washington is saying those plans must include telemedicine. So the bottom line here is, under the Washington rule, those insurance plans that did not cover telehealth services now are being required to cover telehealth in Washington. And then the last rule is insurance companies are prohibited from enacting new rules to try and get around these regulations. So that's really what that last one says. One of the, before we get to the end, to address a question, one of the issues with insurance is telephone services. So under the Medicare rules, telephone services are different than telehealth or telemedicine, and are not eligible for Medicare reimbursement and in the same way as telehealth. Now, this is being relaxed a bit, and on a case-by-case basis, what I've been hearing is that insurance companies are allowing you to bill for telephone services as if they were telehealth. What I would recommend, though, is if you are doing telephone services or might be, and you're in network with insurance, contact the insurance company and get some specific guidance on how to code telephone services, and what the coverage looks like for that. Because what you absolutely don't want is you don't want the insurance companies to be able to come back and claim that your billing was fraudulent, right? So for example, if you're coding a telephone session as if it was telehealth, right? What you really want to do is get some guidance from the insurance company saying, if you're doing telephone services, code it as telehealth, document that, and now you have a good defense if they say, that's not, it was fraudulent that you called it telehealth when it was actually telephone service. All right. Well, we made it through the material. So let's take another 5-minute break. In our 5-minute break, I will review the new questions that have come in, and then we'll come back together and we'll address the rest of the questions. And I think before you go on your break, I think Shannon would like to just mention a couple things to y'all.
Yes. So thank you again for attending the webinar today. I think this is the 4th one we've done. They keep filling up. So we do really appreciate everyone joining. We also, as a board and organization, Washington Mental Health Counselor Association, are really trying to get things to people in real time. So when we see changes or legislation changes or insurance companies changes policies, we're really trying to get those things emailed out to our members. One of the things we are doing today is if you paid for this webinar, we will actually give you half off our membership, and I will send that coupon out to everybody that is on the call today. So if you do want to join, you can, basically the cost of the webinar will go towards the cost of membership. One of the other great benefits of membership is that Eric is available for ethical consults, and WMHCA will cover the cost of those. So you can have a 15-minute consult with Eric, and we will cover that. So again, if there's any other questions or if there's anything else that we as an organization can help you with right now, please reach out to us. My email is shannon@wmhca.org. And as I said earlier today, I will send a link out for an evaluation. When you complete the evaluation, shoot me an email back and I will get a certificate to you. I might not get those certificates out to everybody until next week. And then I will also send all the slides.
All right, everybody, see you in 5 minutes. 5 minutes left. Let's work through these questions and see if we can get it all covered. Okay, so the first one was about Wi-Fi connection, and a question about, wait a minute, if Wi-Fi is not secure, what am I supposed to do? Okay, so let's clarify that a little bit. A public Wi-Fi connection may not be secure, meaning, and I'm not even sure where you would get this. Oh, I know. So you've got a, you're getting on a neighbor's Wi-Fi that is not password protected, or you have a community hotspot, something like that. That is not secure. If you're using your own Wi-Fi connection in your home, you need to make sure that you're making that a secure network, at a minimum, having it password protected. Now, if you don't have a secure Wi-Fi connection, there's a couple options. You can, on a public Wi-Fi, you can create what's called a VPN, a virtual private network. And there are specific software applications you can get to do that. The other option is you can just create a hotspot from your phone. You can create a Wi-Fi connection to your cellular phone, and actually that connection is much more secure than a public Wi-Fi connection is. So the bottom line is, whatever way you're connecting to the internet, just make sure you're not connecting through a public Wi-Fi. Okay. Technologically speaking, there was also a question clarifying about the relationship between Zoom and Doxy. And they are two completely separate services, completely independent of each other. So Zoom is one option for a video conferencing platform. DoxyMe is a different option. It makes sense to potentially have two separate options, just in case there's connectivity problem with one or access difficulty with one, you can use the other. But just to clarify, those are two completely separate services. So we had several questions about working with kids and with minors. So the place that I would start with that is to sort of clarify a couple things. One is a minor for counseling is under age 13. So below age 13 is a minor. In that case, the parents consent to services. From age 13 to 18, and we'll call that an adolescent, age 13 to 18, an adolescent client has independent autonomy and consent for mental health care. So that adolescent client is treated exactly like an adult would be, as far as they independently consent with no parental consent needed. They also have confidentiality. That information cannot be released to the parents without that adolescent's consent. So in working with kids via telehealth, treat that 13 or older adolescent as if they were an adult. They are the one that consents to the treatment, and you owe them a duty of confidentiality. You can only involve the parents if the 13-year-old consents. Under 13, you need to have the parents consent, and it makes sense to when you're especially beginning to work with a child under 13 that you might very well have the parent in the session as well. With adolescents, if the parent is going to be present, you need to have the adolescent alone first to get their consent to invite the parent in. So the bottom line is age of consent stays exactly the same whether it's telehealth or in person. And at 13, you treat that client as if they were an adult. There were a couple questions, follow-up questions about insurance billing and how to code, and especially how to code phone sessions. One thing that I'll say, there was a question about an insurance company specifically requiring that the place of service be coded as 11 rather than 02. There's no problem with that. So again, remember that all the coding requirements, those are not legal requirements. Those are just contractual requirements with the insurance company. They can specify anything. They can tell you any way they want you to code. That can be their requirement for reimbursement. So your best option is to find out what the insurance company wants you to do and just follow their guidance. If an insurance company says, we want you coding 11 for place of service, not 02, there's nothing wrong with that. There's nothing illegal. That's their policy for how they want things to be submitted. So your best bet is to find out what they want and then follow that. And again, different insurance companies are going to do this differently. A couple resources are to contact the insurance companies directly. Go to their websites, because most insurance companies now are starting to post guidance for telehealth because everybody's doing it. And if you have a biller, consult with your biller about that as well. There's another great question about what about telephone? So 2 scenarios. One is you're using a video conferencing platform where the sound quality is not sufficient to support a session. So what about using the video, but then you use phone for the audio portion? I think that's fine. And if it were me, now there's 2 options. One is you could contact the insurance company and ask them how they want you to code that in that weird situation. I think if it were me, I would code that as telehealth. And my rationale would be I am using a telehealth platform. Because the sound quality is not sufficient, we are augmenting that with another option, right? So I would conceptualize that is not a phone session. That is a telehealth session where you're also using the phone to improve it. So that's how I would conceptualize that. Also regarding telephone services, there was a question about that mandated telehealth training that's going to come into effect January of 2021. Will that be required for clinicians who are providing telephone sessions? Now, until it's fully implemented, we're not sure, but my pretty accurate guess is no, because under the insurance rules, right, telehealth does not include telephone services. That has not been changed. It's being loosened because of the environment, but that rule has not been changed. And this training is tied to the Medicare and insurance um, rules. So my guess is that no, for telephone sessions, you're not going to be required to have the telehealth training. But at the same time, there's a lot of analogs between telehealth and telephone services, so it might make sense to get that training. Okay. There was a specific question about crossing state lines, or a couple of specific questions about that. One was, just to clarify, Washington law does not restrict you from providing services from outside of Washington, and Washington state law does not restrict you from providing services to a client outside of the state of Washington. So Washington state law just says nothing about this at all. The policy that we saw says if your client is located outside of Washington, you need to make sure that you're in compliance with the local rules too. So that's the standard. But Washington law does not restrict you from providing services to a client outside of the state. There was also a question about, okay, the question said, look, you said if I'm out of the state or out of the country temporarily, not to worry about it. Well, what does temporarily mean? Is that up to 6 or 12 months? So I don't know. I don't have an answer to this. There is no definition of temporarily. If it's, if you are providing services from another jurisdiction and it's for one time or it's a week, that's temporarily. If you are living in another jurisdiction for a year, I don't think that's temporary anymore. But again, the reason I don't know is because it's all about what the rules are in that other jurisdiction. So I don't know at what point, say, for example, California considers you to be a resident and subject to having to file taxes. I don't know. If you're there for one day and you talk to a client for 15 minutes and the one day you're in California, I'm almost positive that the state of California would say you weren't conducting business in California. If you relocate to California for a year and you set up a home office and you do all of your work from California, I'm almost positive California would say you owe us income tax because you have been conducting business here. Where that line is, I have no idea. It's really a case-by-case, state-by-state analysis. So if you are going to be, or if you already are, relocated into another jurisdiction and you're going to be there for the foreseeable future, I would strongly recommend that you start looking into what does that jurisdiction require with regard to licensure, both practice license and business license and filing taxes and all that kind of stuff. As kind of a flip side to that, it's always a really good idea to verify your client's location at the beginning of each session. Now, I don't mean make them prove to you where they are, but just verify, are you in the state of Washington? And if not, where are you located? Now, you don't need to, if you recognize the background and this client has been in the same room in their house, you don't necessarily need to be verifying that, but it is a good idea to know where your client is. And another reason for that is if you need to send emergency services. If all of a sudden you have a client in crisis, you need to know where they are so that you can call 911 and send those services to them. It's different than, right, if they're in your office, you know exactly where to send the services. There were several questions and also about working in a home office. So we have the obligation to provide clients with our business address. That's a requirement of our general informed consent disclosure form. You must disclose your business address and your business phone number. You're not required to disclose to clients the physical address of the location that you're in during telehealth. So your business address is the place that they will communicate with you for, say, a records request, or just the route of communication. So my recommendation is keep the same business address, but you don't necessarily have to give them your home address if you're providing telehealth from home. Okay, so I see that there are a few, we got about 10 minutes left, and I see that there are a few more questions that have come in. So I'm just gonna work my way down through these. Um, so is the use of a cell phone covered under HIPAA? So cell phone, traditional phone services, whether it's a landline or cell phone, is specifically allowed under HIPAA. So if you're using Verizon, AT&T, if you're using a phone company, whether it's cellular or ground line, that is already HIPAA compliant. It basically is analogous to interaction. All the rules apply the same as interaction in real life. The restriction is voice over internet protocol. So if you have some other kind of voice service that's going through your phone, but it is not from a phone company, if it's voice over internet protocol, that does require a business associates agreement under HIPAA. Again, when it comes to specifically coding sessions for insurance companies are going to be different. If they don't give you if they don't require a modifier, then you don't have to use a modifier, but it's worth asking. I think we've answered some of these. Let's see, I'm scrolling through. Okay. Okay, I think we've covered these. Let me go back and just make sure that nothing has popped up to the top. Okay, so we've got, looks like about 10 minutes left. Any additional questions that slipped through the cracks so that we didn't get answered, go ahead and type those in. So I see a new question that just came in. What about taking new clients? I'm not 100% sure what the question is. I'll tell you, we're likely going to have to take new clients via telehealth. It doesn't look like this is going to end anytime soon. The traditional standard of care, I would have said before the last couple of weeks, is you really should have a session, an initial session with in person, but that's just not feasible right now. So I think we're going to have to figure out a way to take on new clients virtually, even though it's not ideal. The challenges with that are largely the paperwork. So figuring out a way to get the documentation transferred, but I think the bottom line is we are going to have to take on new clients virtually because this is going to be the condition for a while. And the next question, same rules for working with Indian country? Generally, yes. There might be additional rules or standards based on tribal law, so that will be important to know as well. In most cases, the federal rule applies, the state rule applies, and then Indian law applies on Indian land. So you want to make sure that you're checking that there's not an additional standard that you might have to comply with if you are providing services on Indian country. My guess is right now we're not going to see any additional restrictions from tribal law. The question is, can I use a PO box as a business address? The answer to that depends on what context it is you're using it as a business address. A PO box is probably not sufficient for your disclosure form. And the reason for that is in your general disclosure form, you need to be specifying where the records are kept. That's one of the purposes for the address. Now, if you keep client records virtually, right? If it's an electronic health record system, maybe a PO box is sufficient because there isn't a physical location of the records, and the best way to communicate with you about the records might be through the PO box. So that's a little bit difficult to answer, but it really kind of depends on a lot of other factors. Again, a question about Google Voice. So Google Voice is not HIPAA compliant without a BAA because it is voice over internet protocol. My recommendation, if you are being asked to provide services through Google Voice, is that you get a business associates agreement. I think that is possible now, that Google does have the option, but you're going to have to pay more for it. That is an option, or the other option is to use a traditional phone line. See a question, will insurance companies pay if you move your entire practice to your home? I don't think the insurance companies actually care. whether you're practicing from an office or from your home. What they care about is it in person or is it a telehealth service? So my understanding is I don't think that the insurance company, the third-party payers, insurance companies, I don't think it makes any difference to them whether you're working from home or working from an office. Let's see. And I'm scrolling through to see what else we might not have answered. So asking adolescents for ID, I don't think you need to ID adolescents to confirm their age. I think just asking them is sufficient. That shows your due diligence. You need to know when a client turns 13, because the day they turn 13, now they re-sign the informed consent form on their own. And all of a sudden, when they turn 13, you owe them a duty of confidentiality. But I don't see any reason that you would need to actually ID your adolescent clients. And I think we've got everything. Let's see, and I'm scrolling through one more time to see, and there may be some new ones that came in. Okay, here we go. We've got a couple more that have questions that have come in. We'll go ahead and hit those. Okay. Let's see. And I'm trying to find. Sorry, I see a whole bunch came in. I'm just going back to the beginning of the new questions. Okay. Modifier legally required, or is it insurance specific? A modifier is just, oops, I just see that my internet connection, I just got a notice that my internet connection was unstable for a moment there. Okay, I hope I'm back. Modifiers are just a contractual requirement. It is not based on law. So there is no legal requirement that you have a modifier or that you use a procedure code or that you use location code. It's all just contractual. Basically, the insurance company is saying, if you want us to pay us, if you want us to pay you for the services, you have to provide us with certain information, including a CPT code, a diagnostic code, a modifier to the procedure code, a location code. So none of that is based on law. It's all based on the contract you've signed with the insurance companies. Any specific law, any laws specific to school-based counseling via telehealth? There is not. For healthcare, it's all the same. The complicating factor might be that FERPA applies as well, which is the Federal Rule of Confidentiality for Education. FERPA, however, does not exempt a school-based clinical program from complying with Washington state healthcare rules. So you might have some additional rules under FERPA, but the standards with regard to healthcare all remain the same. Let's see. So questions about rates of reimbursement. If an insurance company is still paying at a lower rate, you have a couple options. Is paying at a lower rate for telehealth rather than paying at the same rate as in person. Communicate directly with the insurance company and let them know that the Washington requirement is that reimbursement be at the same rate. And if they continue to pay at a lower rate, you can always contact the Washington State Insurance Commissioner's office. That is the Washington State office that's responsible for enforcing the Washington rules for insurance companies operating within Washington. So that's the Washington State Insurance Commissioner is the one that you could come to. Should we be charging clients less for telehealth than in person? I think at this point the answer, and this is just my opinion, the answer is no. I think we should not be charging a lower rate, and part of that is because we have an obligation to do whatever we can to make that telehealth service as equivalent as possible to in person. And by charging a lower rate, I think what we're doing is really reinforcing that it's not equivalent rather than saying we're going to do everything we can to make it equivalent. But you absolutely can make a different decision on that. For clients under 13, do I recommend that parents always be present? Not necessarily. I think if you're working with children, so under 13, I think it makes sense to use your clinical judgment on what is appropriate. You might have a 12-year-old client where them independently accessing telehealth is totally appropriate. You might have a 6-year-old client where it's completely impossible to do telehealth without the parent present. So I think that is more a clinical issue. And I would say whatever you determine can be totally appropriate. Yeah, and so a comment about my plan is once in-person is available again, I am going to transition all my telehealth clients back to in-person. Is that acceptable? Absolutely. You are not required return back to in-person and not continue to offer telehealth once in-person is available. If a client refuses telehealth, can you bill for the phone session? Well, again, that depends on the insurance company. You'd have to ask the insurance provider if telephone services are covered. If the client refuses telehealth and their insurance does not reimburse for phone, then their option might be to private pay for phone. So that's going to be just an insurance issue. And the question, how do we get a business associates agreement? You just ask. So any third-party provider of services where you need a business associates agreement, what you need to do is just ask them to provide you with a copy of their BAA. If they say anything other than, sure, here it is, then they're not HIPAA compliant. So that's not something that you need to do other than just asking them if they have one, and if so, to give it to you. Okay, I think we're almost out of time, but the last question here is, so what about emergency procedures? So I think what you want to do, and this is both in a group setting or in an individual setting, you want to have some kind of plan for what you do if there's a crisis or an emergency. The first part of that is you need to know where your client is. You need to have their location and address so that if you need to call 911 or you need to call the county designated mental health professional, you know where to send them. So that's one. Another piece of that might be to ensure that you have contact information for an emergency contact person. So someone else that you can contact in case your client is in crisis or an emergency. Whew, and there we are. We are at noon. Thank you all for all the great questions and participation. Stay safe and stay well. And if I didn't get to your question, you see my email address is right there. Feel free to shoot me an email and let me know that it's just a follow-up question from the webinar today, and I'll be sure to get you a response. Okay, thanks everybody.
Yeah, this is Shannon again. I just want to say thank you too. And again, just please reach out to us if there's anything that we can help you with during this time. We know it's difficult for everybody. Thanks so much, and I hope everyone has a great weekend.